Hello, my name is Natalia Porsche, and I'm an attorney who is practicing law in Biloxi, Mississippi. I practice law in Jackson, Hancock counties, and Harrison County. In this video, I would like to speak about rules of discovery in Mississippi and specifically about criminal cases, felony cases, and misdemeanor cases. So when a prosecutor in Mississippi must disclose information to the defense attorney or to the defendant when, let's say, a defendant decides to go to trial. There are two very important rules in Mississippi regarding discovery. First rule is Mississippi Rule of Criminal Procedure 17.9, and that rule obligates both parties, defense and prosecution, to disclose evidence which either party has. If they decide, let's say, if they go to trial, they must disclose the evidence that they have, the one that they want to present during their jury trial, right? Or let's say if it's a case of misdemeanor, during the misdemeanor trial. So let's look at Mississippi Rule Criminal Procedure 17.9, and let's look at what is the obligation of both parties to disclose information. So failure to make disclosure during pre-trial, if at any time prior to trial it is brought to the attention of the court that the party has failed to comply with an applicable discovery rule or an order issue pursuant thereto, the court may order such party to permit the discovery of material and information not previously disclosed, grant a continuance, or enter such other order as it deemed just under the circumstances. Also, the court may order such a party to permit the discovery of material, but if that party is unsatisfied with the discovery and continuous is not reasonable under the circumstances. Let's say if we have a very major criminal or felony case which is getting tried, therefore the court, a judge can order a mistrial. Okay, and let's look specifically at the case Box versus State. John Box versus State. It's the Mississippi Supreme Court, and the decision was rendered in 1983. So it's a pretty older case. So what happened in that case? Well, John Box was accused of a robbery with two other defendants, and he went to trial and he lost, right? And he appealed his case to Mississippi Supreme Court. His major argument was that a prosecutor, in his case, a state, we're going to refer to a prosecution as a state. So a state failed to disclose to John's attorney or to Mr. Boggs, John, to a defendant, very important evidence. And those evidence, there were photograph of the vehicle that Mr. Boggs allegedly drove into the place where a robbery occurred, as well as the testimony of the witness, very important witness, which a state was trying to introduce basically like just few hours before trial, right? So they wanted this witness to testify right before trial, and the name of the witness and photographs of the vehicle were not disclosed to a defense. So it was a very major felony case. And Mr. Box was facing many years in jail because I believe he was a habitual offender. And habitual, those of you who doesn't know, habitual is a person who has a prior record of felonies, right? So the third felony is a habitual. The person will be sentenced as a habitual in Mississippi. So what happened in this case? So a court looked at everything and said, okay, well, very important major point is that a defense must file motions in order to get that material, right? So you cannot just go to a prosecutor's office and say, a state's office or DA office, and say, hey, I want all my discovery right now at once. No, you have to file a motion. in this motion, you must ask specifically what you are seeking to get, right? So there are things that the state must produce you, such as name of witnesses, major evidence, but also you can file motions, and in those motions you can ask specifically what exactly you need. So, and in this case, in Box versus State, so Box's attorney, Mr. Box's attorney filed motions with State, and he said, well, we need name of the witnesses, we need all the evidence that State will be introducing during trial. And State said, okay. And of course, they said, of course, you have a right to seek those evidence, and we will produce them. Well, they did not produce photographs of the vehicle and name of the witness who will be testifying at trial. So defense again object to this witness's testimony and photographs, but a trial judge allowed it in, and so Mr. Box got convicted. So this is this is what was happening. This is what it's all about, the discovery rule. So this was a major case. Why? Because now we also have a rule which is rule 4.06, which provides that it was amended after that in 1982. So here's the say that under this rule, defense has a right to discover, to obtain all the discoverable information, such as name of the witnesses, evidence that will be introduced at trial, and if a state fails to produce those evidence, then defense has a right to seek continuance, and if continuance is not appropriate under circumstances, then the state has a right to ask for mistrial. So this is what this case and those rules are about. Also, Mississippi Rule of Criminal Procedure 17.9 allows sanctions for towards attorney, right? The attorney who failed to disclose relevant information. But in order to get this kind of relief, you must specifically ask for it. So the defense lawyer must file motions with court and serve a copy of the motions that he or she filed. Motions must be served on a DA office, right? Must be served in DA's office personally or by mail, so that a state must know what exactly defense is looking for. So I hope this video was helpful. I think it's very important. Discovery rules are very important as a bread and butter of defense lawyers here in Mississippi. I don't know how about other states, but discovery rules are very important, and specifically defense attorney must raise his hand and say, I object to this testimony because this was not previously discovered. Or let's say if we have witness on the stand, a major witness in the case who is a detective, and he's testifying and he is saying something which was not previously disclosed to the defense, right? He's saying something, he's changing his story, or he's saying something, he's talking about some evidence which are not in his original report. And there we have a problem. We have a problem because defense was building his case, right? Its case, or her case, defense attorney, based on the evidence that a state disclosed, which were produced to the defense. So that's how defense prepared, and that's basically is an ambush, right? When a state witness brings something else which was not previously disclosed to the defense, that's the ambush. That's suddenly something that defense was not prepared for. Right, so that's kind of a violation of the rules of the game here, right? So like I said, I hope this video was helpful. Discovery rules are very important, so make sure if you have a defense attorney, this is done. If you represent yourself per se, so you definitely need to file discovery request and serve upon a state. Thank you for watching this video. Again, remember guys that this is not attorney's advice. This is not attorney-client communication, should not be treated as such. This is just a general information. Again, my name is Natalia Porsche. I'm an attorney who practices law in Mississippi, in the state of Mississippi. My office is located in Biloxi and on Pass Road at 2434 Pass Road, Suite E, Biloxi, Mississippi. And you can give me a call to set up your consultation. My phone number is 228-229-7500. Thank you for watching this video and have a great day. Goodbye.